I'm attorney Martin Nicholson from the law office of Martin Nicholson, also known as the battery man for my focus on criminal battery cases. Now, I am here on day number 10, my 10th day of covering the Jonathan Majors jury trial, this assault jury trial that's going on in New York. One of the things that people have asked over and over again is he going to testify? Is he going to testify? Is he going to testify? People ask. So, as we know, Jonathan Majors opted not to testify in this case against his former girlfriend, or against technically the state of New York. The defense rested. That means that they just stopped. The prosecution early on Wednesday told the court they basically finished all their presentation of evidence and they rest. And that means the defense is getting ready to do their case. What they did is something that I'd always do in a jury trial, even bench trials. In Indiana, it's called a 50A. Basically, when you're doing a 50A at a jury trial, you're asking for the court to basically give a verdict of dismissal. That it's an involuntary dismissal. And this is what they did in New York. They asked the court to dismiss the case. They didn't think there was enough evidence to prove the case, so it should be dismissed. And the court expectedly denied it. They're very hard to win on those. And most of the time people do it knowing that the court's going to reject it. So then it goes on to the defense case, and the defense then has opportunity to present their case. And in this situation, this case, Jonathan Majors presented 3 witnesses. He presented a doctor, a police officer, and Majors. So he had 3 witnesses, and he didn't testify. And the defense had the expert, a medical expert, and she expressed doubt. She expressed doubt that the injuries were from being hit. She said that they were not consistent with someone being hit. She would have expected some kind of swelling around the ear, some kind of bruising, and they did not have that swelling and bruising that she believed she would have saw. She also said the same thing about the finger. It did not appear to come from like someone twisting it. So the medical expert did not think that these injuries were consistent with someone that had been hit in the ear or had their finger twisted. That was a huge blow, in my opinion, to the state's case, because here is a medical expert, obviously for the defense, that's saying that. But when you look at the pictures do not seem to look or match someone that had that injury. She was asked, is there evidence that this was a sharp blow to the head? And the simple answer was no. There was not evidence that this was a sharp blow to the head. It looks like a cut. This injury looks like some kind of cut that you would get from a sharp object. It doesn't look like someone, cut you by slapping you in the back of your hand, and then there's not any other injuries apparent around the ear. It's like on the back of the ear. It's like, what did you do? Pull the ear back and then hit it? It just doesn't seem right. And their medical expert said, I don't see evidence of a strong blow to the earlobe here because I'd expect to see a significant amount of bruising or swelling, and I don't see it. That was the testimony of their medical expert. And that's common sense, right? That if this was some kind of hit, there would be some kind of bruising or palm print or something. And that's just not apparent. The other defense witness was his agent, Jonathan Majors' agent, who detailed these conversations that he had with his client around the night in question, right? The night of the incident. And he said that, and he received a call around 7:45 a.m., Los Angeles time. And he said it was from Jonathan Majors, his client. And he said that he sounded beyond concerned, distraught, worried. Said, I've never heard him like the way he was on that call. So he described Jonathan Majors as being distraught, worried, really concerned. They were on this call for about 25 minutes, but he wasn't really able to go into the specifics because that would be considered like self-serving hearsay. Self-serving hearsay is basically when you have a witness get on the witness stand and testify to the things that you apparently said or told them, but you're not able to be cross-examined because you have this witness on it. It's sometimes considered self-serving hearsay. It's not allowed to be repeated. You can get on the witness stand yourself and talk about what you would have said or did say, but you can't say, oh, I'm going to have this witness get on there and say the things that I would. Major's agent said that he heard a loud, repeated banging noise, and he demonstrated this by continuing to bang his right fist down on the wooden edge of the witness box. He did it several times in a slow type of motion, and he banged it, bang, bang, trying to mimic the sound that he heard that. He said it was loud from the moment it started, but progressively got louder as it went. He said it basically went on through the entirety of the conversation, but on direct exam. Then on cross-examination, he said, well, it really wasn't the entirety. But the point is that there was a loud banging noise, which obviously was Mr. Majors probably banging on the door. So obviously it was Mr. Majors banging on the door. But, the witnesses can't speculate. They can only say, hey, this is what I heard. They weren't there to witness exactly what it was. So they can't say what it was because they didn't. He was also asked, did he hear any other noise? But the prosecution objected to that, and the judge sustained the objection, meaning they weren't allowed to say it. Now, I don't know what else he heard. Maybe he heard her in the background and the things that she said. There must have been some other noise going on, some other sound, something was going on that the prosecutors did not want the jurors to hear. But he was allowed to testify to the tone of the voice he heard. He said it was rushed. There was fear in it. Stricken fear, but the state objected, and then the judge struck that portion from the record. But once again, the jurors already heard it. When they played the 911 call for Major's agent, he said basically that tone that he heard matched the tone of the call that was made to him. And then yesterday we talked about the issue of money, that the prosecution's witnesses were getting paid money. Well, now it is the defense's time. Remember what I told you? I said, if defense has a witness, they're going to get in there and be asked similar questions. Well, brief examination of his agent, the prosecution did that. He said, so is it fair to say the more money he makes, the more money you make? So the prosecution was trying to show that there was a bias with this witness by saying the more money that Mr. Majors makes, the more money he makes. So he has an interest, a financial interest in Mr. Majors being found not guilty so he can bring him in more money. The part that the prosecutor probably didn't expect was his agent denied it. He said that his compensation was governed by a pre-existing contract. Well, I don't know why the prosecution asked that question, because it seems like they should have known. They should have had a copy of that contract. And if the contract basically says, I'm getting paid, $20,000 a month, he's getting paid $20,000 a month, no matter how much money Jonathan Majors makes. So that seemed like maybe not a really good question for the prosecution. There was also the testimony of the New York Police Department, There was also the testimony of an NYPD officer that recommended the investigation. Now, this is the person that apparently recommended that he should be charged. And he noted that it was Mr. Major's lawyers, not the actor himself, who showed up precinct back in June, which I don't know if they're trying to imply that, Mr. Majors was afraid to show up because he's going to get arrested, but his lawyers showed up. Nothing wrong with that. You have a right to have lawyers. You have a right to remain silent. Well, he brought his lawyers. So there's not really anything that I felt was really improper about that kind of testimony. I mean, Mr. Majors did turn himself in, so he subjected himself to going to the police station, being fingerprinted, whatever they had to do. And also, you have to remember, he's the one that called the police and was there talking to the police that night, led the police to the bedroom or the closet. But it's interesting when you look at this video of the police and her in this closet, it's hard to understand why she can't get up. Look at the video. Why can't she get up? This supposedly happened hours ago. Like she was out partying and all the kind of stuff like that. And then she wakes up the next morning and she's laying flat on the ground, like she can't move, like she's been paralyzed. That just doesn't add up. Like, was she out dancing and having a good time, walking, running, and then she wakes up the next day and the police are pulling up off the ground to make it seem like she just was beat to a pulp and she's laying there defenseless. And then her pants are missing. Like, how did her pants come off? Where are her pants? And the doctor testified that the injury to her hand right here didn't appear to come from someone whose finger's been twisted. She was striking at him. Maybe she struck at him and broke her finger. That's not what the doctor said, but I'm just saying that myself. Maybe when she fell she's laying prone. Maybe when she fell in the closet, she hit the edge of something, fell on her finger, broke. It's just the way that she's laying there on the ground looks really strange, given how she was immediately after the incident happened. That image of her on the ground does not match the image of how she was immediately after this happened. She seems like someone that is coming from some kind of drug-induced state or a hangover, just laying there like that. It just doesn't seem to match up. And also you can see the video of Jonathan Majors running. He's running from her. But yet now the next day she's laying prone on the ground like she can't even walk. But yet there's video of her running and dancing. It just does not seem to add up. And that brings us to the Mariah Carey shirt. Because Mariah Carey has this great song. It's usually a number one song around Christmas time, but this year it got beat out by a song, Rock Around the Christmas Tree. So that brings us to the Mariah Carey shirt. So this brings us to the Mariah Carey shirt. Usually her song is number one around Christmas time. And it's been like that for years. But this year, Brenda Lee's Rocking Around the Christmas Tree beat Mariah Carey's song, All I Want for Christmas Is You. And so I'm changing the lyrics around to say, all I want for Christmas is a not guilty. That is what Jonathan Majors is saying. All I want for Christmas is a not guilty. That's what Jonathan Majors is saying. Now, getting back to Jonathan Majors not testifying, it's a tricky situation. And based upon everything that's happened, I don't think I would put him on the witness stand either. Because one of the things that his defense attorney did in voir dire in the jury selection process, asked the jurors would they disbelieve him as a witness just because he's an actor. And there's not really too much that he could offer that hasn't already been brought out through other witnesses. And that's something that you normally do when you're cross-examining witnesses, direct examine your witness, and also looking at the whole entire defense strategy. You look at, can I get this information out without putting my client on the witness stand? And if you can get it out without putting your client on the witness stand, there's no need to put your client on the witness stand, because some people may get in there and say, you know what, he's an actor, so I don't know if I believe him or not, because he's a professional actor. That's how he makes his money. So the risk of putting him on the witness stand, I think, would definitely outweigh the reward, because if someone is in the camp guilty, his testimony is probably not going to change their mind. Because think about it. They already had some conflicting testimony. They've already have her running, the video of her chasing after him, the video of her dancing. The video of him putting her into the vehicle. It wasn't like he put her in the vehicle, throwing her like a football. You can see the video of him like putting her into the vehicle in like the SUV to try to keep her away. Like, let me get her in here and then get out. This is someone that put her in there and was punching her, throw her like a football. He didn't throw her like a football. So they're seeing that with their own eyes. They're hearing the conflicting testimony of what she said versus what the evidence shows. They see this injury to her ear, this cut to her ear that looks almost like some kind of sharp object cut it, not like a fist. They see that her finger is broke, but they see that she was dancing and doing all this other kind of stuff like that with supposedly a broke finger, but she didn't show any kind of pain with this finger being broke, didn't show it to anybody. There's no blood. There's all this reasonable doubt that what else could he say is, I pushed her in the car. That's what the video shows. She tried to grab my phone because I got a text message from somebody. Well, they already know that because she testified to that. I ran away from her because she was chasing me. I was trying to get away from her. Well, they see that with the video. I called 911. Well, they heard.
In formidable. She been conscious. She got to create bottom down. She got ex-partner.
I led the police to the closet where she was. Well, they saw that. So there's not really anything that I feel like he could say that they already haven't heard. What it could open him up to is cross-examination of those text messages he sent. And then that could make him look guilty for something that he didn't do in this case, but maybe he did back then. Who knows? Because you see, they entered this picture of all this stuff he allegedly threw around. Interesting, though, it looks like the same Bible is in this picture. The point is that it does not seem like there's much benefit for him to testify. The risk definitely outweighed the reward. And so that's why I believe he did not testify. I think it was a brilliant idea not to testify in this particular case, regardless of what the verdict is. Closing statements start tomorrow. They will have the prosecution starts with the close. Then the defense gets to do their close. And then because the prosecutors have the burden of proof, they get to do another close. They get to do a rebuttal to what the defense has to say. And then the jurors are left. I would anticipate that probably most of these jurors have their minds made up already. Closing arguments are not evidence. They may highlight some things and bring some stuff out to make the jurors say, oh yeah. But if their mind isn't made up by now, I don't know what's going to change, because I think the evidence is pretty compelling, or the lack of evidence is compelling, that there's a reasonable doubt, even if he did hit her or abuse or something like that, that they just did not prove the case. In my opinion, it was not proven beyond a reasonable doubt. And if he's found guilty, I think the jurors got it wrong, because I've been following this case very closely, and I just don't see where this is proof beyond a reasonable doubt that he had hit her. And it also would appear that she is the one that initiated, through her own testimony, that she is the one that initiated the altercation. This is your Nicholson Nugget of the day. Thank all of you for liking and subscribing. Just keep the comments coming. Continue to comment back as I can, and give me something to do on my downtime. Also, please be sure to like and subscribe. Thank you.